Welcome to the deep dive. We're heading straight into the already very complex and tragic story of Courtney Clenney, the OnlyFans model accused of killing her boyfriend, Christian Obumseli.
Yeah, and the initial picture was, well, pretty stark. You had Clenney claiming self-defense, talking about an abusive relationship,
Right.
and then you had the prosecution charging second-degree murder.
So
So, right away, big questions.
absolutely. I mean, it was clearly a volatile situation, horrific outcome, but now there's this really significant new layer. Serious allegations, actually.
Allegations that the prosecutors themselves might have improperly accessed Courtney Clenney's private communications.
Exactly. Communications with her lawyers. Legally protected stuff.
And that immediately brings us to, a cornerstone of the legal system, attorney-client privilege.
Okay, explain that a bit. What does it mean, really?
Well, basically, it's the idea that what you tell your lawyer when you're asking for legal advice is confidential. It's protected.
So the lawyer can't be forced to reveal it.
Exactly. It's crucial for a fair defense. It's actually a key part of your Sixth Amendment right to effective legal counsel. You have to be able to talk freely.
Okay, so if these allegations hold water, what kind of information are we talking about? What might the prosecution have seen?
That's the million-dollar question.
And what could it all mean for the murder case itself? That's what we're really diving into today.
Definitely. And I think to grasp why this is such a big deal, we kind of need to quickly rewind to the core tragedy itself.
Good idea. So Courtney Clenney, known online as Courtney Tailor.
Right. And Christian Obumseli, they were living together in Miami. And their relationship, well, it's been widely reported, and we've seen police records. It was marked by a lot of conflict.
Yeah, those reports of frequent 911 calls and the police body cam footage that came out, it definitely painted a picture of, let's say, significant disturbances at their apartment. Things seemed really turbulent.
Very turbulent.
Yeah.
And then came April 3rd, 2022, another confrontation, and tragically, Christian Obumseli died, a stab wound.
And Courtney Clenney called 911.
She did, claiming self-defense. She said Obumseli attacked her, choked her, that she stabbed him because she feared for her life.
But the prosecution saw it differently.
Very differently, based on their view of the evidence. Things like the single stab wound, its downward angle into the chest, the autopsy findings.
And maybe other things, neighbor accounts, digital evidence, perhaps.
Possibly. All that led them to charge Clenney with second-degree murder. And then months later, she was arrested out in Hawaii.
Right. And just quickly, for people maybe less familiar, second-degree murder, what generally sets that apart in a situation like this? Not pre-planned.
Generally, yeah. It usually implies an intentional killing, but one that wasn't premeditated, like first-degree murder often requires. So still incredibly serious, but maybe suggests more of a heat-of-the-moment intent rather than a planned act.
Okay. So we have that incredibly tragic, complex situation around the killing itself.
Exactly. And now layered on top of that, this completely separate but potentially just as significant legal fight is brewing.
Right. This is where things get, well, potentially game-changing, like you said. Clenney's defense team has filed these motions, and they sound serious, alleging major misconduct by the Miami-Dade State Attorney's Office.
And the core of it is this alleged breach of attorney-client privilege we mentioned.
Okay, let's really dig into that. Why is this privilege so sacred in the legal world?
Well, think about it like this. Imagine going to your doctor. If you couldn't be totally honest about your symptoms, worry they might tell someone.
They couldn't treat you properly.
Precisely. Same idea with lawyers. They need the full picture, even the bad stuff, the potentially incriminating details, to actually build the best possible defense for you. Attorney-client privilege creates that safe zone for completely honest communication.
Makes sense. And the defense is claiming this protection wasn't just, like, slightly bent, but broken on a massive scale?
That seems to be the allegation. They're saying prosecutors, or maybe they're investigators, got access to a huge amount of Clenney's personal data.
How huge are we talking?
Reportedly, terabytes. From Christian Obumseli's laptop, obtained after he died.
Terabytes. Just... To put that in perspective, what does that even mean in terms of data?
Oh, it's enormous. A single terabyte can hold, hundreds of hours of high-def video or literally millions of documents, photos. It's a vast digital footprint.
So just a massive amount of her personal life, basically.
Exactly. And the defense specifies that within all that data, prosecutors allegedly saw not just, the expected stuff, emails, texts, photos, even her OnlyFans content.
Right.
But critically, they allegedly accessed confidential communications she had with her actual attorneys.
Okay, and the timing here is key.
Absolutely crucial. This was apparently after the stabbing incident, but before she was formally arrested.
So precisely the time when she would be frantically seeking legal advice, figuring out what to do, sharing her side of the story with her counsel.
That's the core of the claim. And they're saying it wasn't just one or two messages. The defense alleges thousands of files were reviewed. Yes, including many that were supposedly clearly marked, with attorney names like Prieto or Puglisi, or had obvious legal keywords like legal or defense in the file names or content.
So the argument isn't just that they stumbled onto something accidentally.
Well, that's what the defense seems to be implying, that this goes beyond an oops moment with one stray email.
This makes you wonder, how is law enforcement supposed to handle this? When they seize a device, like a laptop, that might have sensitive legal communications mixed in with everything else.
Yeah, there's actually a standard procedure for that, or at least there's supposed to be. It involves something called a filter team.
A filter team? Like a firewall?
Kinda, yeah. Yeah, sometimes called a taint team. The idea is a separate group of investigators and lawyers, people not involved in the main prosecution, reviews the seized data first.
Okay.
Their specific job is to identify anything protected by attorney-client privilege or other privileges and basically cordon it off, filter it out, so the actual prosecution team working the case never lays eyes on it.
So they're supposed to be the gatekeepers.
Exactly. But the defense here is alleging that this filtering process, well, either it wasn't done correctly.
Or maybe it just couldn't cope. Given the sheer volume, the terabytes you mentioned, maybe how the data was organized or not organized.
That's certainly a possibility they might raise. The sheer scale could overwhelm a standard process. Or the more serious allegation would be that the process was maybe bypassed somehow.
Right. Which would mean prosecutors potentially saw privileged communications they absolutely should not have seen.
And you can see why the defense argues this is potentially catastrophic for Clenney's right to a fair trial.
Yeah, I mean, if the prosecution saw discussions about her legal strategies.
Exactly. Possible defenses they were considering, maybe discussions about witnesses, strengths and weaknesses of the case. Even just Clenney's private thoughts and recollections shared with her lawyers for the purpose of getting legal advice.
It fundamentally undermines her ability to prepare her case in confidence.
That's the argument. The defense has used this analogy. It's like the prosecution got a sneak peek at their entire playbook before the game even starts.
That's a powerful image. It suggests the state might now have this unfair advantage, knowing the defense's confidential thoughts and strategies.
But hang on, doesn't the prosecution always try to figure out the defense strategy? What makes this different? Is it just about how they got the info?
That's a really good question. I mean, yes, prosecutors anticipate defenses. But there's a huge difference between anticipating, based on evidence and experience, versus actually reading the private, candid back and forth between a defendant and their lawyer.
Right. It's about accessing the unvarnished internal thought process, the specific concerns, the lines of inquiry they're really worried about or focusing on, information they'd have no other legitimate way to get.
Okay, so because the potential damage is so fundamental, the defense is probably asking the court for some pretty strong actions, right?
Oh, absolutely.
Yeah.
The remedies they might be seeking, they could range quite a bit.
Like what? Fines or something?
Potentially sanctions against the specific prosecutors or investigators if misconduct is proven. But more significantly for the case, they could ask the judge to suppress evidence.
Meaning throughout evidence.
Yeah, any evidence the defense can successfully argue was discovered or developed only because the prosecution improperly accessed these privileged communications.
Yeah.
Like if they learned about a witness only through a privileged email, maybe that witness's testimony gets excluded.
Yeah, that could be significant.
It could be. And then there's the most extreme option, which is much rarer.
Dismissal.
Arguing for dismissal of the charges altogether.
Yeah.
Basically saying the entire case is now so irreparably tainted by this breach that a fair trial is simply impossible.
Wow. So their core point is the bell can't be unrung. Even if the prosecution promises not to use the specific emails they saw at trial, just knowing that information fundamentally changes things.
That's the essence of it. The argument is that the prejudice, the unfairness, is inherent once that confidential wall is breached, regardless of whether they directly quote a privileged email in court. The knowledge itself creates an imbalance.
Of course, the prosecution isn't just rolling over on this.
Not at all. The Miami-Dade State Attorney's Office, led by Catherine Fernandez Rundle, They're pushing back hard against these claims.
And we're getting a sense of their arguments from these ongoing pretrial hearings, right, before Judge Laura Cruz.
Yes. Based on reports from those hearings, it seems their counter-arguments focus on a few key things. First, they're likely strongly denying any intentional wrongdoing, no deliberate spying.
Okay, so they're not saying we didn't see anything, but maybe we didn't mean to see anything privileged.
That seemed to be part of it. They're emphasizing, again, the sheer volume of data. Terabytes recovered from Obumseli's laptop, which apparently contained a huge amount of Clenney's synced personal data cloud accounts, everything all mixed together.
Making the review process incredibly difficult and complex.
Exactly. They'll likely argue they did try to use appropriate filtering procedures. Maybe they'll say a dedicated team was involved.
But perhaps any access to privileged stuff was accidental. Maybe files weren't labeled clearly as legal communication, or they were just buried in thousands of unrelated photos and messages.
That's likely a core part of their argument. Accidental, inadvertent access due to the messy nature of the digital data, not deliberate intrusion.
And crucially, they're probably arguing that even if some privileged communication was inadvertently seen, it didn't actually prejudice the defense case.
Right. They'll likely maintain that their murder case against Clenney is built solidly on independent evidence, the physical evidence from the scene, the autopsy, witness statements, things completely unrelated to any potentially privileged communications they might have glimpsed.
So basically, no harm, no foul, even if a mistake was made.
That's likely a central pillar of their response, that the core evidence remains untainted.
And all these arguments back and forth, they're happening now in hearings before Judge Laura Cruz.
Yes, she has the really difficult job now. She has to sift through all this, evaluate the evidence presented by both sides.
And make some critical decisions.
Critical decisions. Was privilege actually violated? If yes, how? Was it intentional or was it inadvertent? How expensive was any access? And then the big one, what's the right legal remedy here? Suppression, sanctions, something else.
And we don't have an answer yet.
No, as of now, early May 2025, Judge Cruz's ruling on this massive motion is still pending. It's hanging over the case.
You know, this whole situation, it really pushes beyond just the legal arguments in this specific case. It makes you think, doesn't it, about digital privacy.
Oh, definitely.
How secure are supposedly private conversations, texts, emails, DMs, when everything syncs across devices, maybe even onto a partner's computer through shared accounts or networks?
It really highlights that digital entanglement, when your data lives not just on your phone, but potentially in the cloud, on shared devices.
Yeah.
Where does privilege begin and end, especially when a device is seized after someone's death?
And it makes you question the legal procedures, too. You mentioned filter teams. Are they always enough?
Yeah.
Can they realistically cope with terabytes of often disorganized personal data dump?
It raises real questions about whether the traditional methods are keeping pace with the sheer scale and complexity of digital evidence today, and, about the level of trust we place in investigative processes to handle sensitive information ethically.
And then there's a perception issue. For Courtney Clenney herself, regardless of the final verdict on the stabbing charge, does this whole fight over potentially breached legal communications unfairly prejudice her?
Does it create a narrative, even subconsciously, that the state had to sort of peek behind the curtain unfairly? Even if they argue it didn't affect the core evidence, does it taint the perception of fairness?
Could it give the state an advantage that's just unconstitutional, regardless of intent? It really makes you wonder if the push to find truth, the pursuit of justice, can sometimes get tangled up and maybe even compromised by how complex our digital lives have become.
It's a massive challenge. The tools available now are powerful. The amount of information is staggering. But the risks of overreach, of error, of unintentionally crossing fundamental lines like attorney-client privilege, they're just as significant.
So let's try and bring this all together. We have the Courtney Clenney case, already incredibly tragic, a death, a claim of self-defense.
A really complex situation from the start.
And now it's taken this major turn, these really serious allegations against the prosecution involving potentially breached attorney-client privilege.
Yeah, and the ruling we're waiting for from Judge Laura Cruz on the defense's motion, it feels pivotal.
It's going to seriously shape how this murder case proceeds, or even if it proceeds in its current form.
Absolutely, and it really throws a spotlight back onto just how vital protecting those confidential legal communications is for ensuring that basic right to a fair trial.
And amidst all this legal wrangling over procedure and privilege, it is so important to remember Courtney Clenney is presumed innocent of second-degree murder.
That's right. These allegations against the prosecution are a separate legal battle from the ultimate question of her guilt or innocence in Christian Obumseli's death. That still has to be proven beyond a reasonable doubt.
Ultimately, this case is just a stark reminder, isn't it? How hidden details buried in digital devices, the sheer complexity of handling digital evidence, and these fundamental challenges to legal process. They're all critical pieces of the puzzle in understanding modern justice.
It shows how layers of complexity keep getting added in the digital age.
Definitely. And maybe here's a final thought for you, the listener, to mull over. As more and more of our lives or communications or secrets exist in digital spaces, what do you think are the broader implications of cases like this for that collision point between our digital privacy and the bedrock principles of our legal system? How do we navigate that going forward?